This floating charge crystallizes at a specific point, usually if the company defaults on the loan or goes into insolvency.
Okay, so it's like it suddenly becomes solid and attaches to those assets, preventing the company from doing whatever they want with them.
Right. But here's the catch for you, the loan note holder.
Yeah.
Those assets could be long gone by the time that crystallization happens.
So it's like a security blanket with holes in it.
Pretty much. It's there in theory, but the assets backing it up could vanish before you can actually benefit from that protection.
And just to add insult to injury, it seems like even if you wanted to take matters into your own hands, you can't.
Oh, you're absolutely right. This debenture deed doesn't give individual loan note holders any right to directly enforce that security.
So you're at the mercy of the security trustee, which in this case is T&T trustees.
They're the ones holding all the cards.
And what's to say they'll act in your best interest or with any sense of urgency?
Exactly. There's no guarantee. And that's a huge concern for investors.
Now, we also keep hearing about these things called covenants that are supposed to be in place to protect investors. Are they doing their job here?
Not really. Covenants are basically like promises or rules that the company agrees to follow in order to safeguard the interests of the lenders.
So things like not taking on a ridiculous amount of debt or selling off key assets without permission.
Exactly. Those are common examples. Now, in a well-drafted debenture deed, these covenants would be very specific and would really restrict the company's ability to make moves that could jeopardize the security of the loan.
But in this case,
well, it seems like these protective clauses are either missing altogether or they're just so weak that they're practically useless.
so there's nothing stopping the 79th group from, for example, transferring assets or offering better security to new creditors.
Which, of course, would leave the existing loan note holders in a much weaker position.
So it's like they've been given free rein to potentially undermine the very security that was supposed to be protecting your investment.
That's a pretty accurate summary.
And speaking of responsibility, what about T&T trustees? What are they actually required to do to protect the investors?
Well, that's another area where this deed is surprisingly vague.
Really? You'd think that would be spelled out pretty clearly.
You would think. But there's no clear outline of what T&T trustees are obligated to do proactively to safeguard those investments.
So are they just supposed to sit back and hope for the best?
It's not entirely clear, and to make matters worse, there's not even a legal indemnity clause to protect them if they do decide to take action on behalf of the investors.
Wait, so they could potentially be held personally liable if they try to help?
That's the concern.
Yeah.
And that lack of clarity could make them hesitant to act, even if it's in the best interest of the loan note holders.
So once again, you're left in a situation where your supposed protector might not actually be able or willing to protect you?
And it just adds another layer of risk and uncertainty to the whole equation.
So it seems like with this debenture deed, there are a lot of unanswered questions and potential pitfalls.
And when you dig into the legal language,
Yeah.
even the most fundamental question of who gets paid first if things go belly up isn't clearly answered.
You get it right.
I wish I was. You'd think that would be priority number one.
Absolutely.
But the review by Insolvency Law points out that there's no specific clause guaranteeing that loan note holders have priority in case of insolvency.
So it's just a free-for-all.
It's more like a legal gray area, and that's never a good thing.
Definitely not.
Yeah.
Now, I know a lot of people might see that this debenture deed is registered at company's house and think, okay, it's official. We're good. But the source material specifically warns against that assumption.